going to be entering the courtroom in just a little bit. She has a hearing for pretrial motions. Her trial is set to start on Monday, and she will be taking her chances with a jury here in the state of Mississippi on 2 counts. Well, I'm sorry, 3 counts actually. 1 count of murder, 1 count of attempted murder, and then 1 count of tampering with evidence. She has the potential to receive 2 life sentences with the murder and the attempted murder charge. She did get an offer for 40 years, and she rejected that plea deal. So now she is going to be going before a jury starting on Monday, and right now we're waiting for her to come into court. She's in Rankin County Courtroom, Judge Dewey Arthur, and having the pretrial hearing motions. They had a deadline yesterday to get all of those pretrial motions filed, and now today we are going to wait for the judge to enter the courtroom, for Carly to enter the courtroom, and take it from there. So if you are unfamiliar with Carly Gregg and what has happened back in March here in Rankin County, she allegedly killed her mother, Ashley Smiley, and then shot her stepfather, Heath Smiley. And her mother was a teacher at Northwest Rankin. So was Carly. Carly was a student there at Northwest Rankin. And so now we are just waiting to find out what happens along with everyone else. What is the pretrial hearing motions going to be? What are the decisions going to be on them? And how is this trial going to play out? Again, she said to start trial next week, next Monday, and we're going to be following that with you guys the entire way through. So right now we're seeing some action in the courtroom, looking to see, waiting for Carly to enter, waiting for the judge to enter and get the pretrial hearing started. As soon as either the judge or Carly enters the courtroom, we'll go straight into there. But if you guys are tuning in, we do appreciate you watching again. I know a lot of people are focused more on tropical storm, possibly future hurricane Francine right now. We're going to have our first alert weather team in here at 2:30 today for you to give you a detailed look at that forecast for the storms. We're going to be following it all the way through here at WLBT, and we're going to be here for you. But we're all going to bring you this right now, waiting for Carly Gregg and Judge Dewey Arthur to enter the courtroom so that we can get started on her pretrial hearing. We're going to go ahead and go into the courtroom right now.
This one is a sad case. It really is. It's terrible. She turned down 40 years, though, which was bold of her. I don't know how she's going to get out of it if she called her friend over there to show her friend the body. I don't know. We'll see. Hey, Karma. I'm going to mute.
So if you're watching there, we're waiting for Carly and the judge to enter the courtroom right now. We got Carly's, one of our attorneys there on the screen, and it looks like maybe Carly is going to be coming in. We know she'll be entering through that door. That's what we're waiting on, for her to come into the courtroom for her pretrial hearing, motions for pretrial hearing for pretrial motions. Let me get those words straight. Carly is going to be going before the judge today. We're going to find out what's going to happen, find out what motions were filed, and see what the judge has to say about them. Again, her trial starts next Monday, and WLBT Plus and will be there the entire way with you guys, taking you through the courtroom and through the trial. She is accused of killing her mother, Ashley Smiley, shooting her stepfather, Heath Smiley. She is looking at a murder charge for her mother. She's looking at attempted murder for her stepfather, and then a third charge of tampering with evidence. She could receive up to 2 life sentences in prison, and she is being tried as an adult. The murder happened when she was 14 years old. She is 15 now. She's had a birthday while she's been in jail, but she is going to be tried as an adult here in the state of Mississippi for the crimes that she allegedly committed. This happened back in March. We've been following it since the day that this all started. Back March 23rd, I believe, is the day that the crime was committed. So we're going to take you back into the courtroom now. Carly should be coming out in just a moment. The hearing was set to start at 1:30. It is currently 1:34. So it should get started here in just a moment. We're going to take you back into the courtroom.
That's what I think. The medication. I really do think the medication harmed this kid. Due to Gregg rejecting the plea offer, her case will head to trial. Yep, it starts Monday. Yep. I agree, Cammie. This is going to be a sad one. She was only 14 when she did this. 14 years old. Ugh. Yeah, she's facing 2 life sentences right now. She turned down the plea for 40 years. Cammy, I don't think there's
And
an
if you are
age.
just now tuning in, again, what we're waiting for is the hearing for pretrial motions for Carly Gregg. It was scheduled to begin at 1:30. We're running a little late. It's 1:38 right now. But Carly and Judge Dewey Author should be entering the
What happened,
courtroom
Uni?
momentarily. Of course, once they enter, we're cut straight into there. But there's a pretrial hearing, pretrial motion hearing that is happening today. The attorneys had until yesterday to file all the motions for any pretrial for pretrial motions yesterday, and today they would go before the judge to see what his decision or his ruling will be on those. Carly is set to start trial on Monday, and she is facing 2 life sentences for the alleged murder and attempted murder of her
Ugh.
stepfather.
We
Murder of her
suffer,
mother,
Uni, I
attempted
swear.
murder of her stepfather. Carly Gregg was 14 years old when the crime was committed. She is now 15 years old, but she is going to be tried as an adult here in Rankin County. The murders happened back in March. We've been following it here at WLBT since it began, since it happened, and we're going to be with you all week next week while the trial is happening. Don't know exactly how long it's going to take. Now, Carly did receive a plea deal from the state, and she rejected it. They offered 40 years, and Carly rejected that plea deal. So she will be taking her chances in front of a jury, and she's actually planning to plead insanity for the crimes that she allegedly committed. We'll know next week, hopefully, that what the outcome will be of that. But right now, we are just waiting for them to get into the courtroom so we can get started with their pretrial hearing. I'm going to take you back into the courtroom right now, and hopefully, it will get started rarely or fairly quickly.
What in the actual fuck? What in the actual fuck? Like, what in the actual fuck just happened? I don't know. Shh. I gotta bring Tommy out. Hold on. That was weird, bro. Let me see. Guess we're doing long crime. Yeah, much as I hate doing them. Hold on. I gotta let Tommy out too. Tommy. Oh, battery low on my earphones. Okay. I don't know, y'all. It's crazy. Shake the bushes. Yeah, that was weird. Saying Scott H, shut up. I don't know what was happening. Why did it go to that friggin' place of all places? I don't know. It's the weirdest thing ever. Oh, they be dressing this poor baby up like I don't know what. She's tiny. Oh, I need pictures. Oh, all right, let me.
Carly Gregg, call number 2024-34169. We're here by way of pre-trial conference. All right. We'll begin with docket number 168. State filed a motion in limine to exclude motion of punishment. The defendant filed no response. Granted. Give me an order to that effect.
Yes, sir, Your Honor. One question regarding that punishment as well. The attempted murder statute requires bifurcation both for guilt and sentencing. And of course, we would ask that any comments about sentencing be reserved for the murder and the attempted
For
murder.
the sentencing things, yes.
Yes, sir.
All right, docket number 169, motion in limine to exclude golden rule and jury nullification arguments. No response was filed. It's granted. State's giving an order. All right, motion docket number 170, motion in limine regarding facts not in evidence. No response was filed. Granted. Give me an order. Document number 171, motion in limine regarding speaking objections. No response was filed. Motion is granted. Document number 166, motion to suppress urine test. Heard from the state. I read the state's motion. Excuse me, I read the defense's motion. I read the state's response. State's burden of proof. Do you have any witnesses you wish to call?
I'm sorry, Your Honor.
It is the state's burden of proof. Does the state have any witnesses it wishes to call?
Sure, Your Honor. The state calls Corey Gerber.
All right.
swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help me God?
I do. You understand, you're not going to answer this one, answers up to all the questions.
I do.
You may proceed.
If you would introduce yourself for the record.
My name is Corey Gerber.
And, Mr. Gerber, what is your role currently?
I currently serve as the Rankin County Youth Court Prosecutor.
As a youth court prosecutor, do you have experience in information regarding what happens when an inmate is intaked at the juvenile detention facility?
I do.
And is there a policy and procedure put in place regarding drug screening of all offenders once they're taken into custody?
It is the practice of the Juvenile Detention Center to drug test everybody that is brought in. That is my understanding.
And to be clear, could you explain for me kind of the breakdown out at the juvenile detention center? There is the youth part, the court part, of which you're a prosecutor, and then there is the detention part. Is that correct?
They're two separate entities. The Juvenile Detention Center is run by the sheriff. The Rankin County Youth Court is the court, and they are separated by locked doors. We are two separate entities, yes.
Hold on just a second. Let me check. It's on my mic.
Testing.
Mr. Gerber, you said that each inmate is drug screened at admission. Could you tell the court what's the purpose of those drug screens?
My understanding is that every child detainee that is brought to the Juvenile Detention Center is drug tested for the purposes of safety. There are multiple things that are done when a child is brought in. One, they are to meet with a mental health crisis assessor. The other is they are drug tested. And my understanding is that they are drug tested just to make sure that whatever substances are in their body for purposes of medical care.
And are you familiar with the drug screening that's done in conjunction with that?
I am.
Could you tell the court about that?
So those are observed screens. Those screens are taken. Once the screen is done, they are presented to the lab. Then the lab would run those tests. The lab is on site. That is a very expensive piece of machinery. I am not an expert in how that machine is run. I can tell you that that machine is calibrated once a week. Every time that the machine is started before any tests are run, there are controls that have to pass. You have 3 attempts to pass those controls. If the controls do not pass at that time, the machine has to be recalibrated until the controls do pass. Otherwise, we do not run tests.
And Mr. Gerber, do you have any personal knowledge about whether or not that machine was running appropriately on March the 20th of 2024?
I do not have any personal knowledge other than if it wasn't running appropriately, it would not have been running.
So they would not have performed a test if it was not working appropriately?
They would not have ran the test if it was not working appropriately.
You talked about that there's some checks and balances in place and calibration to make sure that the machine is running correctly. How reliable are the results from these particular drug screens?
They're very reliable. If they weren't reliable, we wouldn't use them. We wouldn't waste anybody's time or money doing the tests. I will say they are not confirmed tests. So typically what you have is whenever a urine test is had and you get a result, if that result is a positive test, what would typically happen in a case like that is that urine would be sent off for confirmation. We do not do that. We use that test primarily for assessment, not for any evidentiary value. We are not presenting that information to the court without some other types of discussion.
And so the screening's done for safety. The screening has some checks and balances in place. And you said that the results are very reliable. So if someone had presumed tested positive during one of those screens, like the defendant did in this case, that would be very reliable.
It would be reliable. If there was any question, typically what we would do is send that person for a separate test. Depending on what you're testing for is going to be the question. There are some things that we test for that are not as reliable as others. An example would be methamphetamines. Those are the ones that we typically have the question on. We do send those we don't send that urine for confirmation. Instead, what we do is send the person out to give another sample and have that sent for confirmation.
Court's indulgence. Mr. Herbert, with regards to the test performed by Carly Gregg, has anyone provided you anything to show that that particular test was not reliable?
I don't recall seeing that test, nor has anyone mentioned that it wouldn't be reliable.
No further questions.
Cross-examine.
Thank you, Your Honor. Now, Corey, okay, why was Carly at the youth detention center to begin with?
Under federal statute, a child cannot be detained in an adult facility without an interest of justice hearing being had within 6 hours of that child being detained. As a courtesy to the judge, Carly would have been at the juvenile detention center until a hearing could be scheduled for purposes of that interest of justice. She was there long enough for that hearing to be scheduled. She was transported from the juvenile detention center to the jail here or to the court. I'm not sure where she was sent after that, but that hearing was scheduled.
Okay, so, because according to the statute, she's considered an adult, correct?
Yes.
Okay. And so, my understanding, why is it that everybody is tested in the youth detention center? Isn't there some federal grant that y'all are under that requires that?
I'm not certain whether there's a federal grant that requires everybody to be tested or not. Again, my understanding is they are tested out there for purposes of safety reasons.
Okay, so she was only going to be held there for a few hours until she could be brought over here to Rankin County. Is that
As
right?
soon as the hearing could be scheduled, correct.
Okay, and so there wasn't a warrant or anything like that to have her do this test, correct?
Not that I'm aware of.
And there was no probable cause where somebody was saying that we want this test done, correct?
I'm not certain. The only thing I can say is that she was tested for the same reasons that anybody else that would be brought to that detention center was tested for.
Okay, but she was an adult and everyone else would have been children, correct, or youths? Okay, correct.
She would be classified as an adult. She's still a child.
Yes, I agree with you. She's still a child, but she would have been classified as adult.
Yes.
Okay. And so now when you were talking about the test itself, and you said that it's calibrated once a week. Okay. Is there like a logbook that you have that says that it's calibrated?
I don't calibrate it. I just know that the protocol of practice is that it is calibrated once a week, and that's going to be the first start, typically on Monday.
So you don't know if these things are even kept. Is that correct?
Oh, I don't know. I don't. I'm not the person running the machine.
Okay. And the night that this happened, who ran the machine?
I have no idea.
Okay. And if I showed you the test card, would you be able to tell us who ran the machine?
Yes.
Okay. Yeah, approach the witness, Your Honor.
Yes, show it to counsel officer. Anything we're going to show the witness, let's mark that. Can
No objection, Your Honor.
you mark that P1 for identification?
Yeah, that's the test card that we have. In fact, that's the only document that we have concerning this test.
This is the only document. There's no there's no back sheet to this.
That is the only document that we've been presented.
Then no, I can't tell you who ran the test.
Okay. From looking at that document, can you even say that it's calibrated or it's been checked or anything?
I can't. Not from looking at this document, no.
Okay. Now, once these samples, these samples are given, and you said they're taken to the lab, and the machine's in the lab, is that correct?
That's correct.
And then they're run at that, the samples run at that point.
It is run once the machine is started. So, a better answer for your question, is that if the sample is taken at night and it's placed in the lab would be started by the person that runs the machine when they would get there the next morning, and then it would be ran in. So, I don't know what time this was taken. I can tell you the date that it was taken based on this. It was collected on the 20th, according to this sheet. And it would have been ran the same day at 9:21.
Okay. And when these samples are, I guess, run, what happens, I guess, is there going to be extra fluid? Or is it marked and then it's put in the, I guess you'll have a refrigerator or something?
So yes, that we do have a refrigerator, but no, the extra fluid is disposed of. We do not keep the urine, not to my knowledge.
Okay, so you run this test. So let's get back to this, where you say you use the test for, because the test is for the youth court, basically. Is that correct?
Well, it depends on the case. I mean, yes, I mean, if this child were to be a child under the jurisdiction of the youth court, this test could be used for multiple things. One, to give the detention staff an idea of what is in that child's system for purposes of maintaining the child at the juvenile detention center. The second could be for purposes of disposition. The youth court is a court of rehabilitation. We want to address the whole child. So if I see this particular test, I can tell you that it's positive for cannabinoids in an amount of 237.7 nanograms per milliliter with a cutoff of 820. That would indicate that this child has consumed some type of cannabinoids. We would want to know that moving forward for purposes of A&D assessments and possibly enrolling them in some type of program to address cannabinoid use. If there is a question as to whether or not this is accurate, what would happen at that point is we would send that child for something else. But these tests are reliable, they're just not confirmed. So there is no, I would not use this as an evidentiary test.
Right, and that's what I'm getting at, is an evidentiary test to say that is actually what it is. That's not what you use them for, and that's not what they're designed to be used for, correct?
That's not what I use it for. Again, this is just an assessment tool used by the court for purposes of disposition. In the event that there's no contest between the child or the person, the donor, sometimes adults get these tests. If there's no contest about what is found in these tests, at that point they can be submitted to the court. But I do not submit these to the court for evidentiary value and adjudication.
And so where we're at right now is, you said they're calibrated. There's no calibration documents or anything that I provided you or that you have in front of you, correct?
I don't have it, no. If you haven't provided it.
And I think the only thing I gave you is a test card that was given to us.
That's correct.
Okay. And so that doesn't tell who did the test. It doesn't say if the other safeguards had been done on the test. It doesn't. Is the person even qualified who ran the test? We don't even know that, do we?
I will tell you that there are only certain people that are allowed to touch that very expensive machine. They are all qualified to run it. But I can't tell you who did that particular day. As to your other question, it was collected by someone in the Rankin County Sheriff's Department. So that would be a detention staff, but I do not know who that would have been. That information can be gathered, but I don't have it.
No further questions, Chairman. Yes. I'm trying to steal your exhibits.
Read away.
Raise your arm. Mr. Gerber, as I understood it on cross-examination, you said these tests are for, again, safety and medical purposes for the detention staff as well as the donor?
As well as disposition. In the adult world, that would be sentencing. We want to make sure that we have all the information available to us to make sure that the rehabilitation process happens. So they have multiple uses, yes.
When the detention center finds someone is tested positive for a substance like Ms. Gregg did in this case, why is that important for them to know from a safety standpoint?
Well, for example, if it had been fentanyl, we would have taken the child directly to the hospital. The other is we want to make sure that there's no interaction with anything else that's going on. I don't work in the detention center. I don't want to speak for them, but I mean, I think it's fairly obvious that we want to know if the child is under the influence of any type of drug while they're in the detention center.
And if the child admits that they've used drugs, would that tend to corroborate the test results as well?
Yes.
Do you have any information that Ms. Gregg did not corroborate this test as you sit here today?
No, I don't have any information.
No further questions, Your Honor.
Stand down. State may call its next witness.
No further witness, just argument, Your Honor.
Defense have any witnesses that wishes to call on this issue?
No, Your Honor.
All right, argument by the state.
From here, is voting, Your Honor. The state outlined in our response and then filed an amended response. I want to bring that to the court's attention. Initially, we believed that the Juvenile Detention Center was under a particular grant through the OJJDP, which is the Office of Juvenile Justice and Delinquency Prevention. That federal grant does require drug testing. Upon communications with the Board of Supervisors, it's actually a different grant than we initially cited in our response. So I did file an amended response attaching the appropriate grant that does in fact require drug screens of all offenders at entry. Or that does require, drug screens, as well as the Rankin County Sheriff Department's Juvenile Detention Center Policies and Procedures 2.2F. Those were provided to me by the Sheriff's Department, which again outlined that each offender is screened there at the detention center immediately. It also outlines the policies and procedures that are to take place upon entry. These screens, as you heard from Mr. Gerber, are very reliable. The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least. We believe that this information is certainly pertinent since she has asserted her right to claim an insanity defense. As this court's well aware, in cases such as Crawford v. State, once the defendant puts their sanity at issue, the door is thrown wide open for the admission of evidence of every act of the accused's life relevant to the issue of insanity or sanity and is admissible in evidence. That's Crawford v. State, 867 Southern 2nd, 196. Additionally, Mississippi Rules of Evidence 703 state that an expert can rely on facts and data that are not necessarily admissible in evidence. And so our doctor, Dr. Pickett, has relied upon Carly's admissions of using marijuana as well as this presumptive test to show that is and does call into question her mental state. As this court is also aware, voluntary intoxication is not a defense to murder. It does not entitle you to an insanity defense. And so we believe that 703 as well as Crawford and the admissions by the defendant make this test even more reliable. This isn't just a piece of paper that shows that she had marijuana in her system. We have the defendant herself saying that she'd smoked marijuana at or around the time of the crime, as well as additional witnesses that we intend to introduce. As outlined in our arguments, we also believe that this urine screen is akin to the DNA buccal swab found in Maryland v. King. There was a 3-part test. We believe that it's similar in that the Rankin County Detention Center's booking policies require that all offenders be screened, that urine, and also that urine sample is the least and minimally invasive drug screen that's available to them at the time. And as such, we believe that the drug screen itself should be admissible under Maryland v. King. Also as cited in our arguments, and what Mr. Gerber talked about today was that these tests are done for the safety of both the offender as well as the facility. And we believe that that record is actually a part of Carly Gregg's medical records. And because of that, and because of her claim of insanity, she has waived all medical privilege with regards to anything that might have to do with her mental state at the time of the crime. Specifically, we cite to Rule 503F of the Mississippi Rules of Evidence, as well as the cases outlined in our response. We ask that the state be allowed, that our evaluating psychiatrists be allowed to review and talk about the results from this urine screen as they do affect the defendant's mental state at the time of the crime. And then additionally, we would argue that if a search warrant was required, Holloman v. State would apply. In this case, it was a drunk driver who killed someone driving in a car. Law enforcement was on the scene. They observed the presence of beer cans, empty syringes, and bottle containing unidentified liquids. At the time, the person's blood was drawn, and also a urine sample was taken. There was the presence of methamphetamines and cocaine. This sample was taken without a warrant, similar to what we have here, and the court found that a warrantless search is permissible in certain exigent circumstances if it can be shown that grounds existed to conduct the search that, had time permitted, would reasonably have satisfied a disinterested magistrate that a warrant should be properly issued. And similar to Holloman in this case, the substances that were in Ms. Gregg's system at the time can dissipate over a period of time. And this screen was done on the 20th. She was brought over hours later. And we would argue, Your Honor, that if a warrant was got, if we had received a warrant, had to serve it on her and get an additional sample, that would be even more far removed than this sample was on the 20th rather than the 19th at the time of the crime. We would, of course, also state that, as pointed out, it's going to come into evidence that Ms. Gregg was using marijuana. And we believe that if it doesn't fall under the warrantless search and for the safety and within her medical records, and the alternative, the state would argue that this would fall in the inevitable discovery doctrine. And admittedly, under that doctrine, you have to show that law enforcement, there was some misconduct, and that but for the misconduct, these items would have come forward. There's been no such misconduct in this case. However, there is a test that outlines when things would come into play if it was inevitably discovered. And we believe that's the same thing with a urine screen. Based on admissions by the defendant as well as other evidence, law enforcement had at the time in their possession illegal substances, the presence of the vape pens that they had seized from the house, and knew of the fact that there may be a potential for drugs to be in her system. We would certainly ask, Your Honor, to consider all of those exceptions and rule that the urine screen would be admissible for its purpose of showing that marijuana was in fact in her system and not for a quantitative state.
Response.
Thank you. First of all, Your Honor, I'm just going to briefly touch base. The state brought up the fact of basically the indigent circumstance where you can draw blood. The Supreme Court of the United States changed that in McNeely, Missouri versus McNeely in 2013. You now have to have a warrant. So when the state's saying that you do not have to have a warrant in that type, like in the hallway situation, that was a different time. That was okay at that time. That would have been under the Shoemaker ruling that said that there were exigent circumstances and that you could get away with not having a warrant. That has now changed. The one thing I want to say is that with this charge, Carly was charged as an adult, and she was taken to the youth detention center, and it puts her in a different status than most people that are going to the youth detention center. Most of the people that are going to the youth detention center are being handled as youth. In fact, I would say all of them except a very small, minute amount. In that In Carly's situation, she's entitled to due process, which is there has to be a warrant, there has to be probable cause, there has to be some of the protections built in. They bring up the Maryland v. King case, and they say, well, in Maryland v. King, there was actually a state statute that mandated certain testing. And the Supreme Court was looking to see if that was viable, if that was a viable law. And they came back and they said, yes, if there was it validated the law. It said that there was a judicial reason for them to have the law, to have the testing. So therefore, what they did in Maryland versus King was okay. That's not the type of situation that we have here. There is no Mississippi law. There is no federal law that says that this shall be done. This is just the policy and procedure of the Rankin County Detention Center. And so what's happened is she's entitled to due process, and that didn't happen in this situation. There is no probable cause, there is no warrant. That was testified from the stand. The next thing that I want to bring up and put to the attention of the court, in order for a test to be valid, you have to have the person, and this is under Mississippi law, and this is any of these chemical tests, you have to know who the person is performing the test. You have to know the testing procedures. It has to be laid out somehow, and it has to be presented to the court and say, hey, this is done. And then the last thing is there has to be something to show that it's reliable. And the way they show that it's reliable is having calibration records. You have the information of who did the test, how it was done, when it was done, and it was done according to the way the test was supposed to be carried out. We don't have any of that. The only thing that has been presented to us is a one-page paper, and on the bottom of the paper, it's document 1 of 1. It's not 1 of 10 or something like. There's a whole bunch of other documents that go with it. You have a test card. The other thing that comes into play is the state is wanting. They say, first of all, the test is not designed to be a standalone test. It is not to say what you're seeing in that test is what's in her system. It's only an identification test. They use it for that purpose. They do not use it for evidentiary purposes. What the state's wanting to do is take that test and then turn it into evidentiary purposes. They say, well, we just want to have it as like an identification kind of thing. Well, no, they're wanting to, in their reports, they're going in and trying to say whether or not she's under the influence at the time based upon that test, which is an invalid test. It does not show, it doesn't meet any of the requirements of being a valid test by how it was done, who did it, was it calibrated, did they follow the protocols? None of that stuff. None of it has been provided to us. And also, there's been no consent. There's been no testimony if there's no consent. There's no warrant. The test wasn't done right. It's being used for a different purpose than what the youth detention center uses it for. For all those reasons, Your Honor, we ask that the test be excluded at this time.
Mr. McKinney, any reply?
Yes, sir.
I believe that Missouri versus McNeely deals with warrants for blood draws, and in this case, we're talking about a urine screen. Also, Mr. Camp mentioned the laws in Mississippi and the statutes about calibration, and I believe what he's referenced it to is the implied consent law, which talks about intoxilizers, not the drug urine screens. Again, we believe that this does fall within the exceptions as cited in our amended response and also argued today. And more importantly, we believe that it falls within Ms. Brett's medical records, upon which she's waived any privilege to, as well as under Rule 703, that our expert should be allowed to rely upon the presence of marijuana in her system at or near the time of the crime, including the day after the offense, to render his opinions regarding her mental state at the time. We ask that the urine drug screen not be suppressed in its entirety, Your Honor.
All right, this court looked at several different cases, in particular Skinner, Von Rath, Vernonia, Maryland versus King. In addition, the court also read Chandler versus Miller, and Ferguson versus City of Charleston. In this particular case, because the need for a warrant is greatly diminished here, where the arrestee was already in valid police custody for a serious offense, supported by probable cause, the search is analyzed by reference to reasonableness, not individualized suspicion. Reasonableness is determined by weighing the promotion of a legitimate governmental interest against the degree to which the search intrudes upon an individual's privacy. The court would find that the government has there's a legitimate governmental interest in determining whether or not somebody is under the influence in the juvenile detention center, not for the purposes of prosecution, but for the purposes of safety of the accused. Obviously, like Mr. Gerber testified, if somebody tested positive for fentanyl, there's serious withdrawal issues. Well documented. It's not hard to find that out there. I'm not sure the juvenile detention center is equipped to handle those type of situations. That's a valid governmental reason to do it. Looking at Skinner, Von Rath, and Vernonia, the court believes that falls into that. Additionally, the court looked at Jones versus State, Mississippi case cited 881 Southern 2nd 209. The physician-patient privilege was waived in this particular case. And in Jones, the evidence was actually used to prosecute the person. That was not the intent of this evidence. The intent of this evidence was to find out whether or not there was a critical medical need that needed to be assessed at that moment. Now, the court would have a different holding if the state was attempting to offer this to prove possession of cannabinoids or some other crime, but that's not what it's being offered for. In retrospect, the state was able to go back and look at that and raise it for the defendant's insanity defense. So for those reasons, in the case law cited, Maryland versus King, the court would also find that a urine analysis is the least invasive and most reliable method to obtain a drug screen. A needle would be very invasive. Buccal swabs are not considered to be very reliable. The saliva type testing. Hair testing is invasive. You're removing a piece of hair from the child's body. And in addition, the reliability of those in short periods of time are not where they need to be, so to speak. It shows too great of a window. So for those reasons, the court is going to deny the motion to suppress. However, the court is going to restrict the state. You're not to get into this in your case in chief. It can only be used if and when the defendant raises their insanity defense. That'll be the court's rule and states to give me an order. All right. Next matter was a motion for gag order document number 177. The response was filed late. As such, it will not be considered. Motion for gag order is granted. Give me an order. Next motion is document number 175. Motion to enforce the court's previous orders and compel the motion in limine to exclude evidence not previously discovered, produced, and discovered. Again, the response was filed late. Document number 174. Motion in limine to exclude insanity defense, exclude testimony of Dr. Gerald O'Brien, Dr. Mark Webb, and Dr. Clark. Again, there was a late response filed. However, we're going to have to deal with the issue of late file discovery. So I want to hear it all at once. State's motion, I'll hear you out.
Court's indulgence, I'm trying to get it.
Once again, that together, for the record, even though the responses were filed late and the others, I did read them before I granted the motion. All right, you can see.
And I'll start with our, motion to enforce the court's previous orders to compel a motion limited to exclude evidence not previously produced in discovery. This court entered an order directing both parties to exchange discovery that was in their possession at that time by August the 20th, 2024.
I think I actually worked on it 2-3 times before.
That's correct, Sharon. The last order regarding discovery said that all discovery within the party's possession, there was also an in-court hearing regarding that, was to be turned over or the possibility to be excluded.
All right, let's go.
So
What are you trying to exclude? Which witnesses?
yes, sir, Your Honor. So as of August the 20th, 2024, the state had 0 witnesses from the defendant and or any substance of their testimony. So we filed this motion on August the 30th, asking that pretty much any evidence that they sought to introduce at that point be excluded because we had received none. So to be clear, the defendant had dropped off an external hard drive, a jump drive at our office. It contained photographs. It contained an investigative journal by someone by the name of Amber Floyd. It did not contain anyone's testimony, anyone's information, and we were not provided the substance of anyone's testimony. During that same meeting, this was plea negotiations. The state had offered and asked, and quite frankly begged, for the names of anyone who would provide any information regarding the defendant's potential mental state at the time. We were not provided that information. However, the defense attorneys told us during that meeting that they knew the names of several teachers, as well as had a statement that the victim, the living victim in this case, Heath Smiley, had prepared, where they had sent him questions and he responded to those questions in writing, as well as other witnesses. We asked that that be turned over on that day. It was not. We've asked that it be turned over subsequent to that, and it was not until September the 3rd that the state received a list of witnesses from the defendant. And I apologize, Judge, may I get that?
You have a copy of it?
Yes, sir.
Of the list you received.
Yes, sir, Your Honor. On September the 3rd, the state was emailed a witness list that contained the name of Heath Smiley, stating that his proposed testimony would regard his personal knowledge and observation of the events on March the 19th, 2024, his relationship with Carly's mother, Carly's relationship with Heath, Ashley Smiley's mental and physical state, which we've been provided no documents to that effect, Carly's behavior and mental health issues from the fall of 2023 through the present. At this point, we still have not been provided any documentation, any statements, anything regarding any mental state other than the records that we've requested from 2023 outside of Mr. Smiley's interview with law enforcement on April the 4th that we provided. Additionally, it says that he will talk about the investigation in this matter by the Sheriff's Department as well as the Rankin County District Attorney's Office. Essentially, Vicki Breland has pretty much the exact same substance of testimony. That is the deceased victim, Ashley Smiley's mother. Next witness is James Daniel Floyd. He is the brother-in-law of the deceased victim, Ashley Smiley. We have no substance of his testimony other than he will testify regarding his personal knowledge and observations regarding the events on March the 19th, 2024, and the investigation by the Rankin County Sheriff's Office. No information provided by him other than that, with the exception of contact information. BG, who the state has interviewed, and SR, who the state has interviewed. Next, they list a Shira Higby. It is believed that Ms. Higbee is a teacher and that this is one of the individuals, again, that the defendant knew about far in advance of August the 20th, as well as Tricia Gilbreth. Again, it appears to be a teacher of Carly's that the defendant knew about far in advance of August the 20th. They next name Dr. Andrew Clark, which he was not retained before August the 20th. So of course that was not in their possession at the time. We have a separate motion regarding Mr. Clark. And then Corey Garber, which we do not object, of course, to the testimony that he provided. But certainly, so we're asking that any testimony that Mr. Smiley is called to testify about outside of the two statements that he's provided to law enforcement in this case be excluded. We ask that any testimony by Vicki Breland regarding anything at all be excluded, that the testimony of James Daniel Floyd regarding any type of testimony be excluded, that BG, anything outside of the interviews that he's provided to our office be excluded, and those have been turned over to the defense, as well as SR. Same thing for her. Our office provided statements to them, recorded and typed up interview notes. And then we're asking that Shira Higbee, Tricia Gilbreth be excluded. And of course, we asked separately that Dr. Andrew Clark be excluded. But those were all people that were in the possession of the defendant prior to August the 20th, 24. In addition to...
Hang on before we leave that. Do you have a copy of the witness list?
Yes, sir. May I approach?
Mark, yes.
And Your Honor, for the record, I'm going to show it to them. I have the email where it was sent September the 3rd at 4:15 to our office. May I proceed? We, of course, outlined our arguments within our motion as to why we believe that those witnesses should be excluded. I mean, first and foremost, the fact that they violated this court's multiple orders regarding discovery, that by their own admission, they had this information and for whatever reason chose to wait till September the 3rd to produce it. There's no good reason other than willful conduct for them to have done such. There were multiple conversations between the state and the defense about turning over this information. This is not new information. This is not something that wasn't in their possession. This is something that we certainly believe is akin to a willful attempt to hide evidence. We ask that each of those witnesses, with the exception of Mr. Smiley, and the testimony that he's previously provided to law enforcement, be excluded. Would the court like for me to proceed with regards to our other motion in limine for the experts?
No. Any further argument as to these witnesses?
No, sir.
I'll hear the response.
You know, we provided the state a witness list. I think it was sent over on the 3rd of September, if I remember, and I think that's what it was told to the court. I don't think the state is saying that they're surprised as far as any of the witnesses. I think what they're asking for is for the witnesses to be struck. I have brought some case law dealing with that issue for the court, if I may approach, Your Honor.
I'd like to see your case law.
Dealing with, when we're talking about witnesses being struck and everything, Your Honor, the issue of witnesses not being allowed to be used, it gets into the issue of surprise, whether or not the other side is being surprised. Most of the time, in all the case law, it is either in the middle of trial when that's taking place, or right on the eve of trial.
What about Page versus State?
Again, Your Honor, I'm not familiar with Page versus
Page
State.
versus State was 11 days before trial. The defendant provided a list of witnesses, but did not provide the substance of their testimony. He made the exact same argument that you've made before this court in regards to an affirmative defense of alibi. And the Supreme Court said the court was right to strike it down and exclude it.
Well, my understanding of following in looking at the case law as far as, what has been provided and everything, most of the witnesses that we have are witnesses that we have gotten from the state.
Okay, the Supreme Court's also dealt with that. There is no exception. Under the defendant's requirement to disclose witnesses in Davis versus State, 9.04C1 clearly required the defendant to disclose the names and addresses of all witnesses in chief, which the defendant may offer at trial, together with a copy of any written or recorded statement or oral statement they were aware of, and the substance of any oral statement. The rule contains no exception for a witness who is referenced in materials that the state produced in discovery. So I will start here. Show this your burden of proof. Show me what you produced as to Heath Smiley.
We don't have any written statements from Heath Smiley.
Did he give you any oral statements?
Just what the same thing that he's given to both sides. I mean, that's the.
Great. So all he'll be able to testify to is what was provided in the state's discovery, correct?
That's correct, Your Honor.
Okay, so he'll not be testifying to anything other than what he's testified to in open court or what he's given a statement on.
That's correct.
Okay. All right, that was pretty easy. Vicky Breland, show me what you produced.
I think it's what has been proved. Has there been anything? It's what's on the witness list, Your Honor. There were no written statements from her.
It's not just written statements.
There was no.
You practiced law here for 20 years. You know this. You know this. They told you something, you have to turn it over. So if Vicky Breland said, hey, I knew A, B, C, D, she doesn't necessarily have to write it down. You have to tell them about it. Y'all show me what you produced. Is there anything else that you produced other than what's on escrow?
No.
James Daniel Ford. Show me what was produced other than James Daniel Ford.
It would be the same, Your Honor. There's no written statements or anything. It'd be.
What about oral statements? Did he give an oral statement that would be relevant?
I'm sorry. Your Honor, Dr. Clark talked to Heath Smiley, and that is in Dr. Clark's room. So that has been furnished.
When? What day was that furnished?
On the 6th, I believe, Your Honor.
September?
September 6th.
17 days after the fourth discovery deadline the court did?
Yeah, it wasn't a conversation I had with Heath Smiley. That is, we're just bringing it to the court's attention that those statements are in, Dr. Clark interviewed Heath Smiley. I was not present.
BG. What was produced in relation to BG?
I guess the same thing that is on the
Right? SB, SR.
same thing? Same thing.
Sheriff Hicks.
Same thing, Your Honor.
Tricia Gilbert.
It's gonna be the same thing.
Okay, let's start, let's take Tricia Gilbert first. And I understand your investigation, it seems that you didn't do the discovery.
I did not do this, I did not do this list, I have not talked to these witnesses. These witnesses, I am dealing with other witnesses in other part of it, so I'm not familiar.
Okay, so let me ask you this. Even though the rule prohibits this, the court's gonna require 2 attorneys to respond to this, okay? So I'll let Ms. Todd take this, all right? Did Ms. Todd deal with these witnesses?
Yes, Your Honor.
Thanks.
Your Honor, I wish.
Hold on just a second. As to Tricia Gilbert, what did you turn up?
Your Honor, during a session I had in the DA's office with Ms. Newman and Ryan Berry, I relayed to them that the oral statements that the teachers had made to me during that session. In fact, it was even referenced in their expert report, which we got last night at 6:30 p.m. Our expert
We'll get to
report,
that. We'll get to that.
yes, sir. Our expert
So
report.
what do you have, other than your word, that you gave these statements to the state?
Well, Your Honor, I didn't record my conversations with the state, but I also told the state during the documents that she's talking about is my direct examination. They asked me if I had any written statements for any witnesses,
That's
and I
not
said,
what the rule says. Did you speak to Tricia Gilbert?
briefly, Your Honor,
What did Tricia Gilbert tell you she's going to testify to?
she's gonna testify to what exactly I told the state she was gonna testify to.
No, you tell me. I have to make
Yes, Your
I'm
Honor.
making a decision.
She's gonna testify that she was one of the last teachers that saw Carly on the day she left the courtroom, and that Carly did
Where's
not
that
seem
at?
angry.
Where's that?
Your Honor, I don't have the witness list in front of me, but I believe it says in the witness list. Thank you, Your Honor. Your Honor, in the witness list, it says that she will be regarding her personal knowledge and observations from Carly from the fall of 2023 to March 19th. Carly's behavior and demeanor during the fall of 2023 to March 19th, 2023, based on her personal knowledge of Carly's relationship with her mother, Carly's personality, and her relationship with Heath Smiley, and Carly's performance in her classroom. That's exactly what she's going to testify to. And the reason we took it back to the fall is it shows you that she's had Carly in her room for that long. She knows what she's like.
So what did she tell you that you intend to elicit?
I just intend to elicit that when Carly left the classroom that day, she did not notice anything that seemed Carly was upset, that Carly was angry, or that Carly had anything but a positive relationship with her mom.
Where is that in there?
Your Honor, the state sent us the same stuff in their witness list. I had this conversation with the state in person. Didn't feel the need to write it all out again.
Okay. So you don't have any proof other than what you say as to Tricia Gilbert,
I mean, I could call Ryan Berry if I needed to, but no, Your Honor.
He's a lawyer, he's not a witness.
Well,
But if you feel the need to, I'm not gonna stop you. But that's not, how's that relevant? How's what you just said relevant? That she seemed fine when she left school?
Well, Your Honor, I think it goes to Carly's demeanor, Carly's personality, and it will go into what,
State have any objection to a teacher saying that she seemed fine when she left school that day?
I mean, if that's what she wants to elicit from that teacher, and that's her only testimony, that she seemed fine and she had a great relationship with her mother, we would love for them to call her as a witness.
All right, nothing other than that.
that's
Let's
right.
go to the next witness.
Okay.
Next witness. What's the-
Andrew Clark,
Going in reverse order. We'll go with expert session.
Sheer Higby, same thing.
Okay. Show the court what you turned over in relation to Sheriff.
The same thing that's listed here, that she anticipates that she'll testify regarding her personal observations of Carly from the fall of 2023 to March 19th of 2024, Carly's behavior and demeanor from the fall of 2023 to March 19th of 2024, her relationship with her mother, Carly's overall personality and performance in her classroom.
All right, what's she gonna testify to about the relationship?
Exact same thing to what the other teacher will testify to.
Well, let's articulate it clearly.
Okay, to articulate it clearly, Your Honor, she'll be testifying to that she's known Carly and had Carly in her classroom for the better part of a year during the 2023-2024 school year. She saw Carly on the day of March 19th, that she has known Carly and her mom for quite some time, that Carly is a good student, a good kid, not a troublemaker, not a troubled kid, and that
That's a lot of character evidence for what particular pertinent trait.
Your Honor, I think it goes to what the state will be trying to introduce as Carly having some troubled child with a history of violence, which is just not true.
State have any objection to the witness testifying that that witness taught her that year, she saw her on that day, that she's a good student, a good kid, not a troublemaker, not a troubled kid?
I think the last part we would object to until after Ms. Gregg testifies, and then she can put on her character witnesses. But as far as her observations of Ms. Gregg on that day, that she was not, didn't seem in distress or abnormal, and that she had a good relationship with her mom, we do not object to that testimony, Your Honor.
All right. Court will allow that testimony and that testimony only until we get to character witness testimony. Who's the next witness on your list?
The next witness on our list is SR, followed by BG. These witnesses are the same witnesses the state's going to call, and we're calling them for the same reasons, Your Honor.
So you didn't turn anything else over, no statements from the juvenile witnesses,
I
right?
haven't even spoken to SR. So
What about BG?
BG spoke to him briefly, but the testimony is the same thing that the state recorded in their interviews.
All right. But they won't be allowed to testify to anything other than what's in the state's interviews. As the court pointed you to the case law, there is no exception to the discovery requirement for the defendant just because they're listed in the discovery by the state. So you can't elicit anything that's not in their report.
Wasn't planning to.
All right. Who's the next witness?
The next witness is James Daniel Floyd.
All right. Show me what you turned over in relation to Mr. James Daniel.
Your Honor, the only thing we're anticipating calling Mr. Floyd about is just what he saw on the day of the investigations. I have not had personal conversations with Mr. Floyd. He's just going to confirm the demeanor of Mr. Smiley during the investigations when the police were at the house.
How's that done?
I think it will be relevant to the case in chief when we start talking about the investigation that's going on and cross-examination with the
Well, I
state.
thought you weren't, he's not testifying to the investigation. What's he going to testify to about the investigation?
Your Honor, I feel like talking about this now is somehow going to prejudice Carly with the jury, so I'd rather.
Ms. Todd, you can't hide evidence. You can't go to trial and then not know what the witness is going to say. This is basic 101 law. Mr. Kent, can you cite me a single case, one, where a defendant got to go to trial and not tell him what the other side is going to say?
I definitely agree. We have to turn over our evidence to you.
And we're late. We're real late. Who is James Gilbert? I'm sorry, what was the name of the witness?
James Floyd,
Yeah, who's that?
Carly's maternal uncle.
Excluded. That's excluded. That's excluded as a willful discovery violation. That statement right there, there's nothing that's been turned over of any substance. Excluded. Next witness.
Next witness is Vicki Breland, the maternal grandmother. And it's going to go to the statements she made, not to me, but to the statements she made to the expert witness, Dr. Clark, regarding the family's mental health history.
When was that turned over?
That was turned over on the 3rd, Your Honor. We got the state's expert witness report last night at 6 p.m.
You complaining about the state's rebuttal witness to your witness is a bit like a lady standing in the street holding a Christmas hand screaming she's hungry. You were ordered to turn over an expert witness July 28th. You told me it'd be July 22nd. After the discovery deadline passed, we had a new expert witness was hired. So you juxtaposing what they've done with what you've done. Bottom line, what did you turn over to them? Show me what you turned over to them in relation to the grant.
The relationship would be the statements made to Dr. Clark, Your Honor.
That's in Dr. Clark's report.
And again, Your Honor,
All right.
both the state and the defense had to retain new experts after the discovery deadline was passed.
Well, now the state's expert was retained before.
The state's expert in being Dr.
Well, the state retained Dr. Gugliano. You instructed the defendant to plead to assert her Fifth Amendment rights during that conversation.
No, she didn't, Your Honor. She
It
didn't.
says so in Dr. Gugliano's report.
2-1 question.
And then I just got finished reading some of Dr. Pickett's report, and we're going to get to that. We're going to get to that. But let's stick with the grandmother and what she did. If you want to take shots at them on the expert witness, we'll do that. Show me what you turned over in relation to the grandmother before August 20th.
Your Honor,
Before
we didn't
August-
have anything for the grandmother before August 20th. That only occurred after the report we received from Dr. Clark, in which Dr. Clark spoke with the grandmother.
You're representing that you had no conversations with this defendant's grandmother.
Not to the nature of anything with the case. We have discussed the trial in general and explained the trial process, Your Honor. We have talked about how Carly's doing, but not anything that would go to testimony that she would put on at trial.
All right. Before we move on from that one, I want to hear a response from the state. Does the state have had the opportunity to speak with her?
Your Honor, no, and I'm looking at Dr. Clark's report. There's no mention of an interview or discussion with Vicki Breland. If they could point me to where in the report it says
You
he
have
relied
Dr.
upon
Clark's
it.
report, you have a copy of Dr. Clark's report.
I don't have it with me, Your Honor, but he did have a
Let's go get it.
conversation with Ms.
Go get it. We can move on to the next.
I mean,
I can't talk about Dr. Clark's report if you don't have a copy.
would you like me to proceed with Mr. Smiley until we can?
Sure.
Same thing with Heath Smiley. He has given a statement in which was listed in Dr. Clark's report as a 90-minute Zoom conference call. He has done a witness interview, which we received from the state, and several just with the body camera footage of things that happened on March 19th. That's what we're calling him to talk about.
Heath Smiley's testimony will be limited to the matters turned over for August 20th.
Your Honor, I would also cite that Mr. Smiley testified before this court, and we have that transcript on June 4th. The state has that, so we intend to elicit the same testimony at trial that we elicited on June 4th.
You're allowed to do that, so before August 20th.
Perfect.
So before August 20th. All right, is that everybody on the list?
Yes, Your Honor.
All right, if you would return to the court's exhibit. And while we move to Mr. Camp, I assume you're handling the expert witnesses. Is that what's your?
Yes, Your Honor.
All right, Ms. Todd, I think your office is across the street. You can go get a copy of Dr. Clark's.
Well, if the state has it, I can reference it right
Yeah,
here.
mine has writing on it, Your Honor. I don't have a clean copy of their
I need a clean copy of Dr. Clark's report, please. Somebody.
That's not his report.
It's hard for us to proceed without a copy of the report. Y'all need a few minutes to go get a copy of the report.
Yes, I didn't bring a copy of his report with me today.
I can't really address what the grandmother or Heath Smiley said without seeing Dr. Clark. So let's take is there another motion we can handle while somebody gets a copy of them? Either one. When there's two lawyers, I don't
Can you get
care.
a copy?
Yeah.
Okay.
Well, Your Honor, I don't think the court has yet ruled on the state's motions that we did timely file, in which we also asked that the state not be allowed to make speaking objections. We also asked that the state,
I did rule on the speaking objections.
Your Honor, our motions were so good, they filed the same minutes. As to the
They're
speaking
great.
objection. and-
Thank you, Your
They're
Honor.
granted. I didn't see those. They're granted. Do we have any other motions we can hear before somebody can get me a copy of Dr. Clark's report?
We can do we have our cursory motion to move it down to the youth court that we filed sometime before.
I'll be happy to hear that. Can we work on getting Dr. Clark's report? Someone.
Yeah.
Your Honor, may I address briefly the substance and just cite the court to the attachment that I filed, which shows that we were missing each statement, the teacher's names and substance of their testimony, Dr. Webb's report, and potentially a journal of Ashley. That was on August the 20th when we signed for it. So they knew at that time that we did not have the teacher's names or the substance of their testimony.
Is there an alleged journal of Ashley Smile?
We do not have a journal of Ashley Smile.
Does anybody have an alleged journal of Ashley Smile?
I don't think my understanding, we don't have it. We do not have
Where
it.
did that come from in Dr. Pickett's report? I've been able to read about 17 pages of Dr. Pickett's report. And he references the journal of Ashley Smile. Who gave him? I don't think Dr. Pickett just made up a journal, did he?
We didn't provide Dr. Pickett with anything. So if that would have been something that the state gave him. That's not.
All right, let's take 15-minute recess. Y'all go get Dr. Clark. 15-minute recess.
Gosh. What do y'all think of this judge, man? He is brutal. No joke. He really is. No, and she's a little kid. How the hell is she going to wean herself off of anything? Yeah. Yep. He is rough. You could tell he got a problem with her lawyers. For real. You can see that he's got a major malfunction with her attorneys. He is. Georgia, yeah. It's bad. Like, sir, can we not be so rude? Can we? I mean, you see how he sits back like, calm down. Lord have mercy. Hold on. I want to. So, hold on.
The Rankin County team.
Share this tab. Okay.
Teenager charged with shooting and killing her mother and injuring her stepfather is back in court.
Governor's Marie Benefield reports in the next steps for the case against 15-year-old Carly Gregg.
Judge Dewey Arthur scolded Carly Gregg's defense during a hearing, calling it bushwhack about their delayed mental evaluation report. The judge said he
called it bushwhack. Bushwhack. Oh, Lord.
Gave them months to turn it in. As a result, he is giving the defense and state prosecutors until the end of business day tomorrow to turn in the documents, or they will not be allowed.
Okay, as long as we get stuff turned in before the 30th of August, then we'll be okay. I don't think we're missing anything. I think everything's already been turned over. We're just working on the report, and we're getting that out as quickly as we can because we need it for ourselves also, not just for the state. We're working on our case, and we need to know exactly what he's saying.
Carly Gregg is accused of murdering her mother, Ashley Smiley, and injuring her stepfather with a pistol back in March. The court ruled the 15-year-old is competent to stand trial. When asked about Carly's current state, her attorney said, Carly is doing as well as can be expected.
Carly's actually doing pretty well under the circumstances. It's been hard being in solitary confinement for as long as she's been in solitary confinement. I think that's something that anybody can identify with. But overall, she's holding up pretty well. She knows the trial's coming up, so that helps.
Carly Gregg's next court appearance is scheduled for August 27th. In Rankin County, Marie Menefeld, 12.
So this is where they say now she's 15. She was 14. She is ruled competent to stand trial. So she murdered her mother in March, shot her stepfather. They had a hearing, and he offered that stern warning. He really is just not the judge to fuck around with, clearly, right? So the prosecutors told the judge that the doctor's opinion is that she's competent. The psychologist testified during Monday's hearing that medications prescribed to her at the time of the murder may have played a role in her behavior. It seems that the medication is going to be relevant to her mental state at the time of the alleged offense. As a psychologist, I do not have expertise in medications. It was revealed that then 14-year-old Carly was receiving psychological help. The defense is expected to argue that her doctor had changed her medications a week prior to the shooting. The state only did a half report. They did a competency as to whether Carly is competent to stand trial. I think that's a waste of government resources. The defense never said she wasn't competent to stand trial. The judge accused defense attorneys of delay tactics in presenting evidence for discovery. Despite repeated warnings, the defense had not presented her psychological profiles at that time. The defense has another doctor evaluating her mental status, but can't say that they have yet to receive a complete report. Yeah, it's not good. None of this is good. I mean, clearly they changed her medications. Let me see here. All right, so Greg's attorney said that the girl's stepfather will testify that she didn't seem to even recognize him when she shot him with her mother's gun. Okay, so that answers another question. It was her mother's gun that she got. And I know that the stepdad did say she looked like a demon. She looked like she saw a demon. She did not recognize me. Let me see here. Oh, look at this. Okay. Goodness gracious. So According to Greg's defense, there is currently a physician performing a mental health evaluation. So this is in the beginning of everything, right? And then the Department of Mental Health as well. As far as the subpoena on school records, prosecutors claim that Carly had at one point brought contraband and a knife into school before the incident and had other disciplinary actions. Her attorneys claim that shortly before she was detained, she was put on several medications, including Abilify. Yikes. Okay, so here are some of the side effects of Abilify. Lots of strange ones. Blurred vision, seizures, constipation, allergies, drooling, dizziness, accidental injury. Let's see here. May interact with antihistamines, anxiety medications, depression medications. So if she was just put on Abilify and she was already taking Lexapro, how would that interact? I don't know. Let's see. Side effects: allergic reaction, high blood sugar, high fever, stiff muscles, low blood pressure, pain, trouble swallowing, seizures, stroke, uncontrolled and repetitive body movements, thoughts of suicide or self-harm, worsening mood, feeling depressed, urge to engage in impulsive behavior such as gambling, binge eating, sexual activity, or shopping. What? 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 Kind of weird. Let's see. They may cause, okay. Generally, Abilify does not cause aggressive behavior, but like other antipsychotics, they may cause aggressive behavior. It is an uncommon side effect that's seen especially during the start of treatment. Well, interesting. Dangerous behavioral patterns recorded with, now this is from a law office, so they treat bipolar, schizophrenia, add-on treatment for adults who suffer from depression, compulsive gambling, heightened and risky sexual behavior, uncontrollable shopping, addiction to food, sex, and alcohol, violent behavior, legal troubles. Sad. Sad. FDA warns about new impulse control. What? What a strange side effect, right? Like, I know. I just think that's really odd. Like, what a weird thing. All right. So, schizophrenia in adults and children. This is what it's used to treat manic and mixed episodes of bipolar disorder, major depressive disorder, irritability related to autism, Tourette syndrome. Okay. The more common side effects are restlessness, sleepiness, tremors, trouble sleeping, akathisia. I don't know what that is. Mild side effects: restlessness, fatigue. Okay. What are serious side effects? Neuroleptic malignant syndrome, which is, blockage of dopamine receptors. Oh, it causes body tremors and stuff. Okay. Trouble thinking or moving. Suicide prevention. Side effects in children. Common cold, stuffy nose, sexual side effects. Loss of hair. These risk of suicidal thoughts and behaviors in certain younger people. Abilify has a boxed warning for increased risk of suicidal thoughts and behaviors in children and adults younger than 24. That's not good. That's not good. Gosh. Warning, box warning. Risk of suicidal thoughts and behavior. Children and adults under 24 who take this antidepressant have an increased risk of suicidal thoughts and behaviors. If you have these, talk to your doctor. Yeah, sure. It's really fucked up when they say that, like what kid who's going through whatever it is that she's dealing with. Oh my God. So she was on Lexapro. The week prior, they took her off the Lexapro and put her on Abilify. That's one of them, one of the medications that they put her on. So I don't know. I feel like it, Sleuth Investigates. I really do. That's where my mind went.
We're going to move in particular to the state's motion to exclude, for lack of a better term, the expert witnesses. All right, as I appreciate it, state wishes to exclude the report of Dr. Gerald O'Brien. Is that correct?
That's correct, Your Honor.
All right. Defense doesn't have a report for Gerald O'Brien, correct?
That is correct, Your
All right, so you confess that, correct?
Honor. There has never been a report.
State wants to exclude the report of Dr. Mark Webb. Is that correct?
That's correct, Your Honor.
There's no report of Dr. Webb. Is that correct?
That is correct.
So you confess as to Dr. Webb.
Yes, Your Honor.
All right. Let's move to, is it Andrew Clark?
Yes, Your Honor. Yes, sir.
All right. Does anybody have a copy of Dr. Clark's report for me?
Yes, Your Honor.
All right. Let's mark that, if you would. Ms. Newman, take a look at it. If y'all agree that's the report you received, let's mark it D1. D2, excuse me.
Sorry, Judge. All right, so right, Tom.
All right, this is the state's motion. I'll hear you out. But was there anybody else that we did not touch on?
No, Your Honor.
So Dr. Clark, right?
That's correct.
Here you
May I proceed?
Yes.
Your Honor, the motion was actually filed on August the 30th, 2024. The deadline for motions for filing in this case. We at the time did not at all have a copy of the report from Dr. Clark. I think we were in possession of a CV, but that was it. We received on September the 3rd at 7:09 p.m. We received a forensic evaluation report from Dr. Clark. We still now maintain that his report should be excluded, not because we didn't have it, but because it does not apply the proper standard for insanity. It does not comply with McNaughton. And we believe that it's more prejudicial than probative and would confuse the jury as to issues, which leads to why we do not think that they should be entitled to mention an insanity defense or insanity. His opinion, again, does not cover the McNaughton standard. It appears to cover a diminished capacity standard, which the state of Mississippi does not recognize. In addition,
Where is this? I was just handed the report called, where in the report is this?
He has a summary opinion, Your Honor, on page 24, the very last paragraph of that page.
I apologize for interrupting.
That's right, Your Honor. We believe that opinion is in reference to a diminished capacity standard upon which the state of Mississippi does not recognize. In our motion, we asked for a Daubert hearing. I do not see Mr. Clark in appearance. I don't know what he looks like, but I asked the defense counsel if they intended to have him here before trial, and I was told he was not going to be here. So again, all we have to rely upon is his report, where in fact he does not cite to the proper standard from McNaughton. There are plenty of cases within this state that have excluded similar testimony when it is confusing to the jury. And again, this might be proper for something at sentencing, if I don't want to put the cart before the horse, but if the jury were to find her guilty when the state then requests for a sentencing of life, this might be appropriate for that, but it is not appropriate for comment in front of the jury at any time prior to that. And again, our motion essentially talked about Daubert and the standard. Again, he should be excluded under 702 because his opinion does not reference the proper legal standard in the state of Mississippi.
Anything further?
No, sir, Your Honor.
Response.
Yeah, if they're arguing that they wanted a Daubert motion, in their motion that they filed, what they're saying is that they did not have a report. And so based upon not having a report, that there weren't any foundations or anything laid at that point. The report was given to them on September 3rd. There's not been an amended issue on this. We have not been put on notice or anything that his report did not suffice them to say that he's arguing McNaughton. He is arguing McNaughton. That is the whole thing that we have talked about. It is not diminished capacity. It is McNaughton. It's what his argument has always been, and that's what we intend to put on if he's our expert.
All right, let me ask this, and you're saying you haven't been put on notice about their argument, but their defense, how can they file a motion on something they don't have?
Your Honor, I agree. We provided that as soon as we got it. We turned around the same day that we got the report. We gave it to them. In fact, I think Dr. Clark did his evaluation on Thursday, and then within a few days had his report, and we provided it to them. That was done as quickly as we possibly could. And I just sort of want to point out, both sides had to get different doctors. Dr. Guglio was the initial person that was supposed to do both the McNaughton and the competency. And then she was not able to do the McNaughton, and so you had to get a separate doctor that then he went and did the McNaughton part for the state. So both sides have had the same issue.
Hang on, as I recall, Dr. Gugliana basically stopped the interview once she asked the defendant whether or not she had ever abused prescription medication, and she basically said, I'm going to plead the fifth to that. She said, I can't testify as to prescription issues. I'm not a psychiatrist. I mean, had the state been provided evidence, not what somebody says. We're lawyers, we're not witnesses, right? They could have gone a different direction. They're both late. Okay, they're both late. You want me to exclude them both?
Well, I think both of them have to come in, Your Honor. And part of this is not again, most of the case law was talking about if it's obviously, I think the court says this is not intentional on either side. This is just dealing with psychological issues, and we had to reevaluate, right at the end. Both of us had to get new experts. Both of us were jumping through hoops to make that happen. We've provided a report. They've provided a report. There's not surprise. There's the trials next Monday is when that's set for. That's the main issue is if the stuff is coming in, if we're giving you, or either side's giving reports right at the last minute, that's what the court sort of is addressing as far as excluding all this information and stuff. And that's not what the intent is. We tried to move heaven and earth to get the new expert down here, get him to do an evaluation and get the report done. And we think the report suffices, and it is definitely not diminished capacity is what we're arguing on.
Okay, well, let's nail this down. Are you arguing automatism by way of involuntary intoxication? Or are you arguing no?
We're arguing but not, Your Honor.
So you're not arguing automatism by way of involuntary intoxication?
We're not saying voluntary intoxication. We're not saying involuntary intoxication. We're saying that there in the report, there's a whole bunch of different issues that are going on, and that's what impacts her ability to make the determination between right and wrong. And that's in a summary at the very end.
All right. With this having been turned over late, if Dr. Clark is available by Zoom to speak to Eden Smiley, he should be available by Zoom to speak to the state investigator, shouldn't he?
I don't have a problem with that at all, Your Honor. In fact, I was surprised that didn't happen with Dr. Pickett.
Well, again, I've already made my analogy about you complaining about Dr. Pickett. Dr. Pickett turned over the report in 7 days procedurally. So you're not on good footing. How about that? All right, anything further?
No, Your Honor.
All right, reply by the state.
For clarification, we have permission to talk to Dr. Clark
That's
about,
what I'm getting to.
Okay.
It's,
I'm sorry.
all right, by way of reply, let's start here. What's the state's objection to you being able to speak to Dr. Clark, even if it's by Zoom or whatever, in order to try to alleviate the late discovery?
Yeah, Your Honor. So in our initial motion, we requested a Daubert hearing and further order compelling them to provide the materials that they provided to the expert. So again, we don't have any 90-minute, he says that he relied upon a 90-minute Zoom interview with Heath Smiley, as well as a 4-hour interview with Carly Gregg. I think we would certainly love to talk to him about what disclosures were made during that, but I think this court has ruled already that Heath Smiley will be limited to his testimony prior to August the 20th and in court. But I still think that there's some things we need to ask. The state still would like a proper Daubert. We do not believe that his opinions meet the standard, and would request that we have a Daubert hearing prior to voir dire, Judge. We don't think that that's fair for us to have to voir dire on an issue not knowing whether the insanity defense would even be argued.
All right, so let's take this step by step. Is the state's objection to the court granting you time at a Zoom meeting? However, and you discussed this with Dr. Clark. What's the objection to that?
No objection, Your Honor. If he's willing to talk to us candidly.
All right. Is there anything else in Dr. Clark's report that you've not received?
Court's indulgent. I'm not sure. He can clear this up. Pages of Carly's diary. It's been my understanding that there's some other diary out there that we don't have. And of course, if the defendant doesn't intend to introduce it into evidence, we might not be entitled to that. However, if he relied upon that, we certainly would want to know which diary he's talking about, the ones that were produced by the state in evidence or the ones that are in the custody of the defendant.
I'm completely lost here. First of all, how does anybody intend to get a diary? You know, that's Hornbook law, that a diary is hearsay evidence. That's basic first day, second year of law school evidence class. How do you propose that you're going to get a diary into evidence?
Of the defendant? Her own statements?
No. Okay. Excuse me.
Yes, sir.
Okay. All right, so all you have is a diary of the defendant, Carly Gregg, correct?
So we produce some of Carly's diaries in evidence. Law enforcement sees some. It's our understanding that the defense is also in possession of some additional diaries that they took out of the home after law enforcement left. And granted,
does the defense have some diaries they intend that they gave to Dr. Clark?
No, Your Honor, everything that was given to Dr. Clark was from the state's discovery.
So it is only the defendant, Carly Gregg's diaries, correct?
if that's what they're saying, the pages that were produced in discovery, if that's all he relied upon, that's fine. We just wanted to make sure that we know what he's relying upon. Yes, sir.
So there's no other diaries by the state?
No.
By the defense?
No.
All right, so there's no diary of Ashley Smiley by the state?
The state did not produce a diary of Ashley Smiley. The defense emailed Dr. Pickett on August the 22nd a typed what they had labeled journal of Ashley Smiley, and that's what Dr. Pickett was relying upon in his report.
Does the defense have some purported diary of Ashley Smiley?
Your Honor, it's a visitation log that I labeled journal, but it was turned over the day I received it to both Dr. Pickett and Ms. Newman was CC'd on the email. So the day I got it in my possession to send to Dr. Pickett, it was sent to the state.
And Your Honor, I apologize for talking over. We are in receipt of that. We're not alleging that we're not.
Whose journal is this?
Allegedly, Ashley Smiley's.
Where did you receive Ashley Smiley's journal?
Your Honor, it was in a packet that the family brought to me that had divorce proceedings and those type documents in there. It's a visitation log that she kept that had various issues written in there. So the day I received it and found it, I gave it to the state and Dr. Pickett, the state's expert.
We have an expert relying on unauthentical hearsay if hearsay is not able to be authenticated. Double hearsay that can't be authenticated. Anything else?
Your Honor, again, we'd ask that we be allowed to have a on-the-record Daubert hearing of Dr. Clark prior to voir dire in this case.
Mr. Kemp, is there an objection to the state having a Daubert hearing before trial?
You know, if they, I guess after talking with Dr. Clark, if they still want to do that, I don't have any objection to doing a Daubert hearing if they need it. Hopefully it can be resolved by them talking with Dr. Clark to clarify that he is doing McNaughton. If he's doing McNaughton, I think that answers their question for him. It's not diminished capacity.
All right. Anything further?
Yes, sir, Your Honor, that Dr. Clark not be able to amend his findings subsequent to our conversation.
All right. Court is looking at Rule 17.2, Rule 17.3, and Rule 17.4. There's no argument that the defendant requested real evidence, that requested discovery under Rule 17. The fact witnesses in this case that were proposed are wholly different than the expert in these courts. I believe I understand what happened with Dr. Webb. The defense can't help but I don't think Dr. Webb was able to give you what you need or what you wanted. You're put in a scrambling position. So you obtained an expert who got it pretty quick. However, the state's right. There are things where he wants, these experts are relying on double hearsay that can't be authenticated. Now, experts can rely on some hearsay, but you have to be able to prove some reliability. I have to be frank, a journal that miraculously appears at the 11th hour is suspect. This is what the court's going to do. Today is September 10th. If the defense intends for Dr. Clark to testify, you need to arrange sometime tomorrow that a Zoom conference can be held so the state can question Dr. Clark. We will meet back here Friday morning, the 13th, and we will have a hearing. If the state wishes to exclude part of it, file a written motion. If you still believe that it is diminished capacity, we will look at it. This case follows the state follows 250-year-old law in regards to insanity. I believe it is a very wise decision that we continue to follow that 250-year law. It has stood the test of time. This court is not going to be a trailblazer. However, there will most likely be, I'm not putting the cart before the horse, but if the jury does not acquit her, there will be a sentencing phase. I expect diminished capacity can be used in the sentencing phase. So while diminished capacity may not be necessarily admissible during the guilt phase, it would be admissible during the sentencing phase. And Dr. Clark be here for a double hearing if necessary on the 13th. To the defense.
If needed, Your Honor, we can get in here.
Okay. All right. This is what the court is looking at. The court finds there was a discovery violation. However, as Dr. Clark, the court is not inclined to exclude the witness at this time. The court is looking at Rule 17.4, the effect of failure to comply. A, granting a continuance or assessing costs against the appropriate attorney or party. Just to be quite frank, we can't promote for 20 years. I don't intend to assess you a cost at this point in time. But I've never seen this from you. If I have to grant a continuance from the 16th, I can continue it to the 23rd. But I'll address that on this Friday. But the court intends for the case to be tried this term. Second thing, B, limiting further discovery of the party failing to comply. This is it. No amendment of Dr. Clark's rule. We're going to ride the horse we brought. Finding the attorney failing to comply in contempt. Or excluding the testimony of appropriate witnesses. Let me do the defenses. All right, the court went over arrest warrant. Court looked at it. For example, Vicki Breedlin is a witness closely identified with the defendant. The late disclosure this court, that's what this court has a problem with a witness closely identified with the defendant. What is provided is not the substance of her testimony. Same with James Daniel Ford. What the rules are concerned with is not a listing of witnesses. Nowhere in the rules does it say provide a list of witnesses. It says provide the name, the address, the substance of the testimony, written, recorded, or oral otherwise. When I look at Vicki Breeden and James Floyd, Shara Higby, Tricia Gilbert, those are witnesses closely identified with the defense. For those reasons, the court stands by its prior ruling. Heath Smiley. Mr. Smiley has made it very clear that he wishes to stand with the defendant. That's a witness, closely identified with the defense. It will be limited to everything he's testified to before or the statements previously provided by the state. As to Dr. Andrew Clark, the court is going to delay its decision, allow the state time to interview the witness, prepare any objections that need to be made, or conduct a discovery. The court believes that's a fair way to allow the defendant to put forward her evidence, whether it be in sentencing or in the guilt phase. But that's going to be the court's ruling right now. We will reconvene here this Friday, the 6th, at 9 a.m. I expect at that time for the state to announce either you're prepared to proceed or we're not prepared to proceed. If you're not prepared to proceed, why are you not prepared to proceed? And what in particular will you need to proceed? All right. The second thing the court will be looking at is a Dahlberg style hearing, if required. We'll be looking at is this diminished capacity evidence or is this McNulty evidence? And I'll hear arguments as to why it's diminished capacity or why it's McNulty at the time. All right, is there anything I've made clear for the state?
All right, just to be clear, the Friday the 13th, right, this Friday?
Yeah, I'm sorry, I said Friday the 6th.
Yes.
Friday the 13th,
Thank
excuse me. Worst day I can imagine how to hear. Friday the 13th, all right. Is there anything I've been clear on, Mr. McCain?
No, Your Honor.
All right. Were there any other motions by the state?
First indulgence. No, sir, Your Honor.
All right, by the defense. Any further motions? Did you want to argue the motion to transfer to youth court now?
Your Honor, I would, Kirk, I'll go to the podium. We have filed our motion. We think that it would be in Carly's best interest, it'd be in the best interest of justice. We filed the motion some time ago. We know we have a trial date coming up, but we'd ask the court if we could transfer the case to youth court in the interest of justice.
Response by the state other than your written response.
Our written response, Your Honor, and just for judicial notice, the youth court prosecutor, Corey Garber, is still present in the courtroom. Just would like to, if the court would like to hear from him on whether or not the youth court would be interested in entertaining his discretion.
It's your motion. Do you want to call the witness or not?
It's not my motion, Your Honor, it's the defendant's motion.
That's your response.
Oh,
If you
sure.
want to call- If you want to call, I might call. it.
Sure, Your Honor. The court, the state calls Corey Garber.
Mr. Garber, do you understand that you were still under oath? Still sworn to testify?
Yes, Your Honor.
Mr. Gerber, I believe back in June of this year, my office contacted the youth court and sent y'all a copy of the motion and possibly our response in opposition to the defendant's motion to transfer to youth court. as a representative of the youth court, do you have an opinion on whether or not the youth court is the appropriate venue or jurisdiction for Carly Gregg, who's been charged with murder, attempted murder, and tampering with physical evidence?
Under the rules, under the statute, youth court should only be handling cases where there's a reasonable prospect of rehabilitation. I have not followed this case, but I'm unaware of any reasonable prospect of rehabilitation in the juvenile justice system for someone who has committed the crimes which you just listed.
No further
Wow.
questions.
Cross-examination.
Corey, if the individual, I guess, had some mental issues and things like that, there are, I guess, different avenues that the youth court could follow, correct?
I'm going to need you to clarify your question.
You have, I guess you have counselors and you have people that could come in and see her, correct?
We do have counselors. So Region 8 has a counselor on staff at the Juvenile Detention Center who visits with children who are detained there, yes.
And right now where Carly's at is she's in solitary confinement because she has no, she's in the adult jail. She doesn't get to, she has to be housed separately. So for this entire time, she is in solitary confinement. She didn't get to interact with any of her other people her age or anything like that. If she was at the youth court and at the youth detention center, would she be able to interact with people her own age?
And she would be isolated. It's like sound separation. She is considered to be an adult. It's fairly clear that under the federal rule that anybody charged as an adult cannot be held and detained the same as a juvenile. When she was detained at the juvenile detention center, she was kept separate from the juveniles there, so she would still be kept separated.
Well, this would be if it's sent back. If she's sent back, she would be a ward of the youth court at that point.
Oh, if you're saying that the case is transferred back and
Yes.
Yeah, I mean, at that point, she would be considered a juvenile, yes.
Right, and she could interact with people her own age.
Sure.
She could be getting counseling. She could be getting things of that nature. What about her schooling? She would be able to be doing schooling, correct?
She would.
Right. Right now, she has no access to schooling whatsoever. So there are actually programs and benefits about going back to the youth court, wouldn't there?
Mr. Camp, I want to clarify. If she were adjudicated in the youth court, these would be the dispositional alternatives. One would be 90 days in detention. So for 90 days, not counting the amount of time that she's already spent detained pre-trial. So, and the idea, the meaning behind the statute would be the intent that she can only be detained for 90 days. So, it would be my understanding she would possibly have to be released upon being transferred back because she's already exceeded the 90 days that would be considered for disposition. Secondly, the other alternative would be Oakley Youth Developmental Center. The average stay at Oakley is 6 months, 6 to 9 months, to which she would be released on parole, all of which she could receive some type of counseling. Yes, the question is going to be, is that counseling, is Oakley Developmental Center, or is the 90-day stay in the juvenile detention center enough to rehabilitate for purposes of the acts that are alleged? My opinion is no.
Now, she could get some help though, correct? That's the only, right now, she's not getting any, I guess she's seeing a counselor through Region 8, but there's no schooling. There's no long-term counseling, but you have long-term counseling at Oakley, correct?
Long-term counseling, again, it would be 6 to 9 months. Should she be found guilty in this court, she would have available to her all of the resources that are available to anyone at the youthful offender unit, which would include possibly education and the like. She would have the adult services that are allowed. The question though is, could she be rehabilitated in the juvenile justice system? I don't, again, haven't followed her case. I don't have a social summary in front of me. I'm not prepared to make that decision other than based on the allegations of the crime. And those types of things are also considered. It's an A through N survey, and the first 6 or 7 factors of that are going to be the nature of the offense committed. That's a lot to be taken into consideration. We're talking about charge of murder and attempted murder. Those are going to be very difficult to rehabilitate in the juvenile justice system. It's just not built for that.
No further questions, sir.
Reader,
There we go, Your Honor.
stay available. Any further witnesses about that?
Nothing further, Your Honor.
Any witnesses in reply by the defense?
No, Your Honor.
All right, any further argument by the state?
Your Honor, none other than what's already in our motion, our response.
Any reply by the defense?
No, Your Honor.
Court's going to deny the motion to transfer the defendant to youth court. I appreciate Mr. Gerber's testimony, but the court was
Jesus.
very familiar with the inherent limitations of the youth court. That's not a knock on the Rankin County Youth Court by any means, but as this court appreciates it, me transferring this case back basically is an acquittal. I don't think that's an appropriate ruling for a court to make. I believe in juries. That's what's going to happen in this case. The jury of this community is going to make the decision whether or not to acquit her, whether or not the homicide is justifiable or excusable, or whether or not the state can prove that beyond a reasonable doubt. Those are not questions for a judge. That is a question for the jury. This court will not stand in the way of the jury. All right. State's giving an order denying the motion transfer back to youth court. All right. We will reconvene here this Friday morning, September 13th, unless I receive an order from the state that no motions are necessary and you're prepared to proceed to trial, or notification to that effect. All right. We'll be back here this Friday morning, September 13th at 9 a.m. Then it will remain in custody. See y'all back there.
And Your Honor, we have one issue that we'd like to take up in chambers with you if we could. Sure.
She is in an adult prison in Mississippi in solitary confinement. The expert they just brought up didn't follow her case, knows nothing of her case, but feels as though because it was murder, there's no way to rehabilitate her. What the fuck is this shit here? This is a child who was an A student, scored a 30 on her ACT in the 3rd grade, skipped a grade. That's like the equivalent of a 1380 on the SATs, has no history of violence, has a history of depression, and was put on Lexapro. A week prior to these murders, she was taken off Lexapro and put on Abilify. They think that none of this has anything to do with anything, and she's just an evil kid who decided one day to kill her mother. Like, I'm so aggravated. This is bullshit. She's a baby. She's a literal baby. I don't understand it. I don't understand this. Why not at least, I don't know, but she can't go to a juvenile facility. And her stepdad said that he came home. Now, I know there are other circumstances, such as her calling her friend and saying, "Have you ever seen a dead body?" And her friend's like, "No." And she's like, "Well, do you want to see one?" And she brought her over to see a dead body, which is fucking horrible and crazy. But if she had a psychotic break, then I don't know. So she brings her over. She shows her friend. Her friend goes out to the backyard to play, which also seemed insane. It made no sense, but that's what they said, that she went out to the back to play, and that's where she was when the police got there. When the stepdad came in the house, into the garage, she was standing there. He said her eyes were huge, and she didn't recognize him and looked like she saw a demon, or she thought he was a demon, that she just seemed crazy or something. He didn't understand what was wrong with her. And then she shot him in the shoulder, and he tackled her, and he got the gun, and she ran. So she runs up the road, and the police drive up the road, and they say, "Are you the kid who was involved in the incident up the road?" And she says, "Yeah." That's it. Yeah. And they took her. I mean, I know Mississippi's tough, but this is a lot. Like, she was 14 and clearly on medication. So it's so concerning to me that she was on these meds and this happened. Work with the Juvenile Restoration Act with some of its authors. The science here is clear. browngold.com blog. Let me see that. I want to see. I can't tell if that's it. Maryland's juvenile. No, that's not it. Blog. I can't copy it. Darn it. Oh, wait. I can if I'm into YouTube. Hold on. I gotta mute myself. I want to see it though. Okay, so sorry, I was muted. Sorry. So I'm just reading this, and everybody should read it because I think it's so important that we realize these are kids. These are kids. In the last hearing, they showed that, let me see if I can get to it on here. Hold on. I think it's on here. Is this even, I'm like, is this even my channel? I never go live anymore, so I'm like, I don't even know. Where the hell is it? Oh, I uploaded it. Okay, wait. Look at this. I want to show you something. Where's the... Okay, let me mute, and I want to show you this part. Hold on.
That'd be a neutral factor. The third factor is the defendant's prior criminal record and any releases on recognizance of bond in the past. There have been none of those things. Those would be to the benefit of Ms. Gregg. The identity of responsible members of the community who will vouch for the defendant's liability. We just had a show of hands of family members. There were numerous family members here who support Ms. Todd's argument about the issue of bond. That factor would weigh in the benefit of Ms. Gregg, whether violence or lack of violence in the late commission of the offense. Well, that's significant. The violence.
Carly could also be allowed to continue attending school online while she waits indictment. It could be months before she's indicted, and at the current bond with no income, she has no means of raising these funds. And that's why we would ask that you consider reducing Charlie's bond to something that she could afford, and we would ask for an unsecured bond.
Those people are all her family. Okay? This is her family. And they want her out on bond. Like, there's grandma's crying and shit.
Moreover, the detention center that is meant for adults is not equipped to do things like provide Carly with schoolwork, with mental health care, with exercise. Well, currently, she doesn't even have the ability to meet with visitors, as the court's well aware of. Based on Carly's budget mistakes, she's already taken mental hurt. We're not even about to be indictment. If it continues at this rate, Carly's citizen trial will be at risk by the time we get to the trial. And again, the living victim's family, the living victim and the deceased victim's family is support for bond reduction.
Sure. Yes, sir, Your Honor. Unfortunately, you forfeit some rights when you deal with a person trying to go leather. School workers have lots of support. They can't forfeit that right when you murder someone. Your Honor, if you talk about unsecured bond, you talk about mental health, and just reports knowledge. The state offered to stipulate to a mental evaluation for this. Said, look, you give this on a Friday, stipulate for free, you're evaluated, say that's a priority, your day, check, no problem. And they did not agree to that. So I think this individual says, one, she has no problems, he's available, and not agree to the evaluation. So that offer expired Friday. And, since that door of bond has been open, as we're well aware, so our pre-section 29, the person who gets a capital offense, bond can be denied. So our bond should be denied. I understand families that are dramatic, and nobody can go through. I feel so sorry for them. The state also has an obligation to protect the community at large, and based on what the state's seen.
I'm assuming, so it's fair to say that the family of Ms. Gregg that sits behind you, can I see a hand of the family members? Is it fair to assume that family members, your argument you present, is it fair to say, let me ask you this way, anybody that, you disagree with anything Ms. Hodge said concerning Ms. Gregg? Anybody of the family disagree with Ms. Hodge? Okay, that's fine. All right, well, there's several reasons for bond, and I feel like I've been instructing today more than I typically do.
Yeah. So everybody wanted her out. They all wanted her out. And they wanted her bond lowered. Her bond is $1 million fucking dollars. $1 million. $1 million. And they wouldn't let her out. And she's in solitary confinement. Queen Bella, it was her mother's gun. I don't know how she got it. I don't know. I don't know. But I guess we're going to find out everything. So we'll be back on Friday to watch if they have a hearing. And then her trial starts on Monday. So anytime that I'm not in a meeting, I'll stream it. But if I have to go into meetings, then I have to stop and come back. But it's one I'm going to be glued to because I think it's really important. Our teens are a mess right now. And that's not due to our teens. It's due to our system. Our system is fucked up. If you can not release her to a facility, while awaiting trial, and you have to put her in an adult prison like she's some hardened criminal, I think that's fucking crazy. I think that is insane. To me, that's beyond I can't. She's a little kid. And she's dealing with all these adults who aren't trained to deal with kids at all. They're not trained to deal with kids. They're there to deal with criminals, hardened criminals, adult criminals. It's very difficult, and I don't want to say about the sex and things that go on in prisons, but we all know that happens clearly, right? So we don't know what the hell we're dealing with over here. You got her in a whole adult ass prison in solitary confinement all by herself. No therapy. She can't talk to anybody. No counseling. No nothing. And you just have her in there. Like, you've got to be kidding me at this point. It's horrible. It's horrible. I mean, and Mississippi is tough, but they're not always tough. There's a few cases out there where justice absolutely is not being served in Mississippi. 1,000,000%. So anyway, all right. I love you. I gotta go now.